This is Tampa Bay's 10 Talk.
It's time for FLALAW, brought to you by the personal injury attorneys of Perinick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday at 5 o'clock, and that means we are here for another edition of FLALAW on the radio, your source for straight talk and solid advice regarding the legal atmosphere. My name is Matthew Noyes. I'm one of the attorneys at the law firm of Perinick, Caulfield, Averill, and Noyes, the oldest personal injury law firm here in Tampa Bay. We've been helping people with personal injury matters and workers' comp and Social Security matters since 1955. That makes us celebrating our 70th birthday this year. And so as a thank you to the community for having trust in us, we want to give up some time to answer your questions without having to really pay for a lawyer to address your questions. So that's why we set up FLALAW on the radio. We are here live every Tuesday from 5 until 6 o'clock to answer any questions that you have. Tonight, I am joined with a special guest who has taken time out of his very busy schedule to answer your questions as well. And he's here to dive into some of the most confusing area of law, and that is employment law. His name is Ryan Barrick, and he is a leading employment law attorney here in Clearwater. He's years experience. I think we've known each other for decades.
Really, absolutely.
And so he is a partner at Qual, Barrick, and Nadeau, where they focus on workplace issues like wrongful termination, wage disputes, non-compete agreements, and even discrimination cases. Ryan is one of the few people in the state of Florida that have board certification in labor and employment law from the Florida Bar. He's a frequent speaker and commentator on employment law. I've seen him on TV a few times. He's now here on the radio. He was a guest on our old show, TV show, FLALAW, when we were live back then. But he is here to answer questions that you have regarding employment law. We're going to dive into some of those issues, but he's also graduated William & Mary and Vanderbilt University, who's having a very good football season this season.
It's a good time to be a Commodore. It's rare, but it's a good time to be a
That's
Commodore.
right. We would visit their stadium. It's like, are they ever going to get that finished? So it's good to get it finished. But he's here. He has represented both management and employees over his career. So he has a wealth full of information having to do with employment law. This is the time to ask questions regarding employment law. There's 3 ways you can get in touch with us. One is by calling us. This is a live legal call-in show. And so you can call us at 727-441-3000. You can visit us on our YouTube page at Perinick, Caulfield, Averill, and Noyes. On our YouTube page, and Ed on the other side of the glass, their producer of the show, will let me know when you have questions. And in a minute or two, we'll be able to also see us live on our Facebook page at Perinick, Caulfield, Averill, and Noyes, Injury Lawyers. And Perinick is spelled P-E-R-E-N-I-C-H. Easy to find. Give us a call with any questions that you have. So, Ryan, again, thank you very much, and welcome to FLALAW on the radio. We're excited to have you here, and I'm sure our listeners are too. So, before we start diving into the questions about your areas of law, why don't we dive in questions about you? Can you introduce yourself to our listeners and, why you became an attorney and why you chose employment law and all those good kind of questions?
Absolutely. Thank you, Matt, so much for having me here today. I'm as Matt said, I'm a board certified labor and employment law. That's all I do, and I really enjoy it. I spent my entire career, almost 30 years, just involved in labor and employment law. And one of the things I love about it is the first thing I do when I meet with someone is I am a client or potential client is I say, well, tell me about your job. What's going on at work? And we spend so much of our lives at work and so much of our time and energy devoted to our jobs that it's something that's very important to many people. And I get to hear about that. And I get to hear about when things are going well. And sometimes I get to hear about when things aren't going well. And the idea is we're learning about different jobs and different industries and trying to help people who are having problems at work deal with those problems and figure out if what's happening to them is illegal, if what's happening to them is just unfair, if they have a claim, how we can work through those issues. And all of those are really just very interesting things that I've been able to, over the years, spend time with people talking about what's going on at their jobs. And I'm looking forward, if people have problems at work or issues that they want to talk about today, we're happy to try and talk with them today on the radio here.
And as you can see, that's one of the reasons why Ryan and I work together so closely over the years, is because we do workers' compensation claims. And so people often have workers' compensation claims that have the employment law aspect into it. And we do not do employment law. And so we always send them over to Ryan or Michelle to try to get the guidance. So we appreciate you helping our clients as well.
It's funny because one of the first things I'll say to people when they ask me about what do, I say, well, I don't do workers' comp, right? For people who aren't lawyers, it's sometimes sort of strange the way the lines are drawn, but workers' comp often is more like personal injury, because the focus is more on what's the injury, how is that impacting you, how is that impacting on your ability to work, and what's your recovery going to be like. Whereas employment law focuses much more on sort of how are you being treated at work? Are they retaliating against you because you filed a workers' comp claim or brought a workers' comp claim? And we help people with those types of claims. But I don't do the workers' comp that you do, because it's one of those lines that sort of, they're very different areas of the law. Up until when the person gets injured, helping them through that injury process, that's the kind of work you do. We do the kind of work where if their boss is retaliating against them because they filed that workers' comp claim, we're happy to try and work with that employee to get back to either that job or bring a claim associated with that job.
And there's so many other issues that make clients come to you, not just a workers' compensation claim. And we want to touch base on those. And I think the first thing I want to really touch base on is the non-compete agreements. We all hear about non-competes. It's all over the news whatsoever. But could you explain to our listeners what a non-compete is? And I guess more importantly, what a non-compete in Florida is? Because I think there's a difference, right?
Absolutely. I think there was a lot of news last year about non-compete agreements, and there was a movement to sort of abolish non-compete agreements nationwide. And unfortunately, Florida sort of leads the country in non-compete agreements. And what non-compete agreements are is it's an agreement that your employer requires you to sign that says you're not going to work for a competitor, and you're not going to work for a competitor for a lengthy period of time and in a very broad geographic area sometimes. And Florida law really is the most pro-employer state in the country for non-compete agreements.
I say that about workers' comp all the time as well. So.
Yeah, it is. And it's really very unfortunate, and it impacts our economy very negatively. It has a real, there's a lot of academic data that suggest it drives down wages, it decreases innovation, because people feel like they can't leave that job to go do something new or something creative because they're afraid they're going to get sued by their old employer. And it's a real problem, and people are afraid to leave because they're afraid they're going to be sued, and that also drives down wages because they can't get that next job that pays as much. So there's a lot of academic research that suggests non-competes are very bad for the economy. Unfortunately, the Florida legislature loves non-competes, and while there's a national trend to outlaw them, in a lot of states they've been outlawing them, in Florida, the Florida legislature this past session passed a law that was even more restrictive for employees.
Oh, goodness. Wow.
So now it used to be sort of the default was 2 years. Now, in certain circumstances, the default can be up to 3 years and sometimes longer than that, which is a long time to say somebody can't go get another job. And the courts are really going to have to confront this new law and how it's going to play out for people. It's one of those areas where you're well advised to get advice before you sign the agreement. It is so much easier for us to try and prevent problems on the front end then deal with them on the back end. So if your employer comes to you and says, hey, we need you to sign this non-compete agreement, take a minute, go talk to someone about that agreement, figure out what it is you're signing and what it is you're committing to do. Don't think that, oh, it's not worth the paper it's printed on. I hear people say that all the time.
Right. No, they can never enforce those non-competes. But that's just not true.
And that's not true at all. And it really can be problematic. So it's worth people taking the time on the front end and figuring out what it is the non-compete says and how a court might respond to that.
When can the employer instruct you or recommend that you sign the non-compete?
I mean, that's one of the things that's sort of crazy about Florida is in some states, they can only do it at the beginning of employment.
That's what I thought. Yeah.
But in Florida, they can make you sign a non-compete anytime along the employment process. So you could be working somewhere for 10 years. They could make you sign a non-compete after you've been there 10 years and a day. And then there's some cases under Florida law that say, if they fire you a few days later, they could still enforce the non-compete against you.
Oh my goodness.
It's crazy. It really is.
And so non-competes have to do with duration. Now, I guess that can be up to 3 years.
Yes.
And it also has to do with radius or distance, right?
So it's funny because in the world we're living in now, distance is becoming less of an issue.
I would imagine, yeah.
Because so many jobs aren't geographically based, right? If you have a job that is focused on, across the United States, servicing clients across the United States, the geographic distance isn't really something that the courts are going to look at because it's not relevant. If you're a hairdresser, then geographic radius might be something that's very important. But if you're some other industry, a sales role that you service clients nationwide, whether or not they're 5 miles or 500 miles might not be a relevant part of the inquiry.
You raise a good questions because I would think of it as a non-compete. You think it would only be managers and salespeople, perhaps, but the hairstylist, I didn't even think of that. But
there's an amazing amount of litigation for people like hairstylists and tattoo artists that are skilled jobs and that have clienteles that they build up over the course of time, and the employer tends to view that clientele as being the employer's clientele, whereas the tattoo artist or the hairdresser views that clientele as being their clientele because they're coming to them for the expertise that they have. Yeah.
Right.
And so there's a really surprising number of cases that involve professions like hairdressers and tattoo artists.
That's very interesting. Yeah, that's Ryan Barrick. And now I can tell you that we do have our Facebook Live page up. So if you have questions for Ryan or for myself, please jump on our Facebook page too at Perronick Caulfield Averill and Noyes Injury Lawyers. Type in the questions there or give us a call at 441-3000. Ryan has given up an hour of his time. He's a busy man. He's doing all kinds of court proceedings and such. And we were talking before the show started is, now his federal court's kind of in limbo right now, isn't it?
Yeah, it's the federal courts are still operating, but what we see is a lot of the federal administrative agencies like the National Labor Relations Board or the Equal Employment Opportunity Commissions, which are two federal agencies that we deal with a lot for employment law.
I could imagine, yes.
Yeah, their funding is on hold, and so they're not really functioning in any sort of normal way.
Yeah.
And that's difficult for people who want to go in and bring a claim and go through those administrative processes because there's not really anybody there to take those claims right now.
Right. And in fact, I got an email today saying that I think one of the federal courts in Jacksonville or something was closing for today. And on Monday, Tampa is closing or another location. And so it's crazy times right now. It makes it hard. But the bad thing is there's no one there to tell you that the courthouse is closed either. Right.
That's right. Yeah. They really, we require functioning courts, and functioning courts require all kinds of people beyond just the judges. You need the clerks who are filing the documents. You need the law clerks who assist the judges. There's a whole cadre of people, a whole universe of folks that are sort of behind the scenes that when somebody goes into court, they may only see the judge, but there's a vast network of people that support the judge. And unfortunately, those people aren't necessarily being paid, or some of them aren't being paid, and it's creating a real stress on the system.
Sure. Before we leave the non-compete agreement, I did want to ask you did say how important it is for someone before they sign to talk to an attorney. What can the attorney do to mitigate, I guess, the impact of a non-compete?
Well, I think the key thing is, one, we can help the employee try and negotiate something different, something less restrictive, either a shorter time, or maybe let's talk about there are specific customers that we both agree are at issue rather than the whole universe of folks. And sometimes it's a matter of the employee decides, you know what, it's not worth signing that agreement. And if that means I have to find another job, maybe I have to find another job. But it's better to make that decision on the front end rather than on the back end. To negotiate, you've gotten more leverage when they want you than at the end of the day when they're kicking you out the door. So
Sure.
when they want you to come in, you can say, hey, if you want me to sign this agreement, there's a thing called a garden leave agreement, which is an idea that if you want me to not compete, you need to pay me to sit out, pay me to tend to my garden.
Oh,
And so that's
okay.
the idea behind a garden leave agreement. So maybe you could negotiate, hey, if you want me to sit out for 6 months after I leave, you need to pay me for 6 months after I leave so that I'm not starving, right? My family's able to feed themselves, but I will sit out if you pay me that money.
And when we say sit out, it doesn't mean sit out from any job whatsoever, but then you can't compete with your prior employer.
That's right. You can't do the job that, and that's really one of the problems is people view themselves as having built up an expertise, and they know that they're going to make more money if they're in their chosen field rather than working in a job outside their field, right? If I were a successful salesman selling something that made a lot of money, and then one day they say, you can't do that anymore when I leave, I don't get to sell my product again, and instead I can go be a clerk at Publix. Well, working the cashier as Publix probably isn't going to pay as much as it would pay in that elite sales position.
Sure. And you lose the context that you may have earned and the skill that you may have earned over those years or decades of with that employer.
That's right.
So we talked about what a lawyer can do before it's signed. What can a lawyer do if someone comes up to you and says, listen, I signed this non-compete and I got this letter from the employer or the lawsuit from the lawyer? What do you need to know, and how can you guide that employee or former employee?
It's when those folks come to us, we look at the agreement, we see if there are some arguments about the enforceability of the agreement. Sometimes there's no legitimate reason why the employer needs the agreement, right? Under Florida law, generally, there needs to be a reason why the employer needs the agreement. And the idea is, it's not enough to have an agreement that just to prevent competition. The employee needs to have access to confidential information, or they need to have access to specialized customers, or something that is valuable to the employer. So if the idea behind the agreement is just to quash competition, courts might not enforce it. And so we talk with people about, well, what was your job and how were you interacting with the customers and what kind of information? And, we litigate those cases, and sometimes we have success for people. It's a heavy lift, but sometimes we have success for people in either getting the non-compete set aside or getting a reduced length of time, or sometimes it's only specific customers, and we work through those issues.
No, that sounds very good. So it's very important that if anybody has a non-compete issue, they just don't say, oh, I messed up, I'm stuck. Right. They should consult with you or somebody like you that handles the non-compete agreements, because there are ways to negotiate such a resolution without so much detrimental impact.
Absolutely. You can negotiate, or if you end up having to litigate, all is not lost. There are arguments we can make. We do have success for people. It can be a hard process. And the better course of action is don't sign it. But once you've signed it, we can sometimes figure out ways to help you through that process.
Good idea. Good idea. Now, I want to move on about something that I think is important. I think with this more remote working, I think probably has a little more impact on it than maybe years past, pre-COVID, and that's overtime pay. Can you explain to our listeners what really qualifies to be paid overtime and what doesn't?
Sure. So it is funny because you're right. After the world changed so much as a result of COVID, and one of the things that really happened was the way people were working was just so different. We had been talking a lot in the practice area about the idea that remote work and work from home was going to come on and going to be a thing, but the way it happened and so quickly was really sort of staggering.
Did you think that was before COVID?
Before COVID, we were talking about that
Really?
was something that was coming on, but I don't think any of us thought it was going to come on as quickly.
I never thought about it.
And the interesting thing is now the pushback that we're seeing to remote work, and like Chase and some other very large employers demanding that employees come back into the office and really trying to push people back into the office, which I think it's going to be interesting to watch that play out. As somebody who talks to people every day about their jobs, there aren't that many jobs where the people actually need to be on site 5 days a week. And so you're going to see a continued pushback as employers try and drive people to be back into the office.
You see there's a claim that way?
If somebody has a disability, it's where we've seen that become an issue is before COVID, where people had disabilities that required remote work. The courts were not very sympathetic to those claims because they would say, well, the employee has to be here. There's value from them being here. It's unreasonable for the employer to allow the employee to work from home. Now, after COVID, what we've seen is 5 years of evidence that people can do their jobs working remotely. And so it is much easier for an employee who has a disability to say, as a reasonable accommodation, I need to be allowed to work from home.
Okay.
Because the employer is hard pressed to say, well, we can't do the job if they're working from home because they've been doing the job of working remotely for 5 years. And just because you'd like them to be in the office, that isn't necessarily a legal basis if somebody has a disability that requires remote work to mandate them to be in the office.
And I know we're going to talk about at will and right to work and all that. And I think that's going to come into play a little bit there. But let's jump back to overtime.
Sure.
Because I think people may not understand who gets paid overtime and what overtime really is and such.
Absolutely. I think when you're looking at who's entitled to overtime, there's sort of two parts to looking at it. One is what's your job? And the other part is how are you paid? And the first part is what's your job? The default rule is everybody's entitled to overtime if they work more than 40 hours. And then there's the except. And that's the big thing, the except. And who does the except? Who isn't entitled to overtime? Well, there are exemptions for professionals. Professionals are things like doctors, lawyers, teachers, engineers, sort of traditional professions. There's an exception for managers who supervise more than 2 employees. So not a manager in sort of I'm in charge of this product line, but a manager in terms of I'm in charge of these people. And then people who perform administrative tasks for the business. So at a high enough level. So the in-house accountant might be considered an exemption, but the accounts payable clerk probably isn't. So the higher level administrative people. So the first part is what are your duties, and those are the traditional exemptions. And then how are you paid? If you are paid on a salary basis, and you have exempt duties, then you're not entitled to overtime. Well, what's a salary? Salary means you get paid the same amount every week, no matter how much you work. So if you work 30 hours, you get paid the same. If you work 50 hours, you get paid the same. So if you perform exempt duties, so you're a doctor, lawyer, teacher, and you get paid the same amount every week, you probably aren't entitled to overtime. But if you are working as a payroll clerk, or if you're working as a clerk in a store, or if you're doing some sort of, depending on what the nature of the sales role is, and you're being paid salary, maybe that's not right. Maybe they still need to pay you the overtime when you work over 40 hours. And the issue is really, it's over 40 hours in a work week. So sometimes people will come and they'll say, well, I worked 37 hours and then I worked 39 hours. It's really the 40 hours is the big line. You have to cross over that 40 hours on a work week basis for overtime to come into play.
And that's what I heard some discussion or some questions about. Was like, I was only scheduled to work 28 hours, but they had me work 35 hours. I should get paid that overtime for those 7 hours. Right. Or I was scheduled to work 7 to 3. I used to be a waiter at Denny's. So I was scheduled to work 7 to 3 and someone didn't show up. So I had to work until 7 p.m.
Yeah.
But I still didn't do 40 hours in that week. I don't get overtime.
You're not entitled to overtime.
Right.
Now it's funny because servers are interesting because for servers, they can take a credit. The employer gets to take what's called a tip credit because if they pay them, a part of their wages is often done as tips. And so the employer can pay them a reduced minimum wage. And where that can become interesting is if the employer at a restaurant has a tip pool. So if you've ever worked in a restaurant, you know exactly what I'm talking about, where they have a tip pool, which is going to be like everybody pulls their tips together, and out of that you tip the bar, and you might tip
The bus boy,
the busser,
the hostess, all that good stuff.
And so where there's an issue is if the tip pool includes the back of the house. So if the tip pool is including the clerks, not the clerks, the cooks or the managers, then the employer has a problem, and the employees might be owed money because they've got people, they're essentially using the employees' tips to fund the operations of the restaurant.
Oh.
So you can tip like if you have an expediter, they can be part of your tip pool in some circumstances, but you really don't want the cooks being part of the tip pool, and they should be being paid independent of the tip pool, because if they're sharing in those tips, then what's happening is the business is funding it on the backs of the employees.
Oh, that's very interesting. I didn't even think about that. I don't think we ever tipped or shared tips with the cooks, but I can see that happening.
Yeah,
in some of the bigger restaurants
and
chains and
the
such.
chains, and I always say there's no shortage of ways that employers can try and come up with to take advantage of their employees.
Right.
And if they can figure out a way to do that, they're going to try.
And I think one of the things that I've seen, especially in like our area of law, in our area of business, is that adjusters, let's say the insurance adjusters, that they manage files, but they don't manage people.
Right.
And insurance companies or their employer says, well, you're a salaried employee, we're not going to pay you more than 40 hours.
Yeah, and I think that's a really good example because their duties don't really fit into the traditional tests. And so even though they're being paid a salary, they're probably due overtime for their hours in excess of 40 in a work week. Paralegals is another one where their duties, they're doing important work. It's not a judgment as to the importance of the work that's being done. It's just the default under our system is you should be entitled to overtime if you work more than 40 hours. And there are some exceptions. But paralegals, adjusters, there are lots of jobs that don't fit into those exceptions. And so if those people are working overtime, they should be paid for their extra work.
And I think you just said, one of the criteria is that they have to be supervising 2 or more employees?
That's right. So that for the manager exemption, they need to be supervising 2 or more employees.
Okay. One thing I've seen also is that there's some companies that want their employees to respond to emails over the weekend or text messaging their staff after hours and such like that. I've always thought that could be a problem.
I think it really becomes an issue of, is it the legal concept is, are you engaged to, or are you waiting to be engaged, or are you engaged to wait? And the idea is the employer paying you, or should the employer be paying you to sit by waiting for that message to come in? Or does the employer not have an expectation that you're going to respond to it until Monday morning? So if the employer sends you an email over the weekend, but there's no expectation that you're going to respond to it until Monday morning, you're probably not entitled to be paid for that. But if the employer expects you to respond immediately, then it becomes a situation where maybe you should start paying those people because they're essentially being commanded to sort of sit there waiting for something to happen, waiting for that message to come in, or waiting for them to be dispatched. If you think of one of the traditional, firefighters, right? Like, we want to have firefighters sitting there waiting for something to happen. We are paying them to sit there for that emergency call to come in. And when that emergency call comes in, we need them to go immediately and deal with that. Well, they should be paid for that waiting time. If somebody's free to do whatever it is they want and they're not really being interfered with, well, then maybe they're not entitled to be paid for that work.
And so do you see a lot of people that have overtime issues, so to speak?
We see a lot of overtime issues. What we're seeing, I think that people are beginning to become aware of And I think, again, this is part of the pandemic pushback to some degree. People are beginning to become aware of the need to draw boundaries and to say, I'm not on the clock anymore. I'm not going to check my email over the weekend. I'm going to let that sit until Monday when I'm back on the clock. And I think that's a healthy thing for people to do. It's good.
I should listen to you because I don't do that.
Right.
And I know you don't
I
either.
don't either, but we should be doing that more.
Yes.
It's important for us to draw lines and to be mindful of, to step away from our work.
Sure.
One of the things that's really become clear to me as I've done this for so many years is that people put a tremendous amount of themselves into their work and value themselves very much based on their work. But at the end of the day, the work doesn't really care about you. Somebody else will do that job after you're gone, and the world will continue to turn. And so you need to be aware of that and spend time with your families and do those other important things, and focus on those big life issues, because the work is always going to be there.
That's true. Words well said. And I agree 100%. It's so important that, you're not people are going to remember you for who you are, not what you did.
Yeah.
So I think that's important. But if somebody does have a overtime claim and they come to you, what's the process? What's the damages?
Sure. So one of the great things about the overtime law is if employees aren't being paid properly and they bring a claim, the law says they're entitled to twice what it is they should have been paid. So if they're owed, $10, it becomes $20, or more often, $50 becomes $100. And the law also has a special provision which allows for what are called collective actions, which are kind of like class actions, but they're actually easier to do.
You can read my mind. I was going to ask you that.
And they're designed to make it so that employees can gather together and bring a claim against their employer for the money that they're due. So even if each person individually isn't owed at that much money, it's real money and it's important for the people to be paid properly. But the ability to gather together, working together, puts them in a position where those are cases that lawyers want to take. Also, the law says if employees aren't being paid properly and they have to sue to get their money and they win, the employer has to reimburse the employee for their attorney's fees. So that combination of the ability to bring people together and the employer's potential exposure for the attorney's fees makes those cases that lawyers are willing to take, because you can get your fees paid for by the employer.
And I think that's only fair, because it's the little guy going up against the employer.
That's right. And there needs to be an incentive. Unfortunately, we don't have enough government enforcement. And so what this is one of those laws where we as a society have determined that we're going to rely on lawyers to enforce that, lawyers to ensure that businesses are doing what it is they're supposed to do. There's just not enough government infrastructure to make sure every employer is paying people properly. So instead, we use a little bit of a whack-a-mole model, which is that the employees who aren't being paid properly, they can go find a lawyer and they can complain, and then the lawyer brings a suit and hopefully is able to get the employee the money that they're due. And as sort of a means to keep the employers in check, they're on the hook for their attorney's fees associated with that.
Which is one of the few now areas of law that attorney's fees are still held in favor of the plaintiff.
Yeah, absolutely. And it is because the amounts can be modest. You need to have that lever so that there's a mechanism to do that. The only other alternative would be to have much more government infrastructure, which would cost us all a lot more money, and people don't want to do that.
Right. And employers can say, well, it's $10 here, $10 there, and 1,000 employees, they're saving all that money at the detriment of the employees.
That's right.
So I think that's very important. Let's talk about, well, before we do that, let's open up the lines again, just in case people have questions. You listen to Ryan Barrick. He is, as you can hear, a very educated, well-versed employment law attorney, a board-certified not civil trial attorney, that's what I'm used to saying, but employment and labor law attorney, one of, I think, only about 200 lawyers in the state of Florida that can claim that title. Ryan's been helping employees for many, many years, and also helped employers during his tenure as an attorney. We are here to help you until 6 o'clock. We are live on the radio, and you can call us at 727-441-3000. Jot us a comment or a question on our Facebook page at Pernick, Caulfield, Averill, and Noyes Injury Lawyers, or go to our YouTube channel as well that you can type in a question there as well. And that's Pernick, Caulfield, Averill, and Noyes Injury Lawyers too. If you don't have accessibility to any of those, but you still have a question after the show, we do post our shows on our podcast, so you can find us on Spotify and Apple Podcasts and all the other podcasts that young people know about. But we are there. You can visit our show on there as well. But you do have about 20 more minutes, so please, this is the time. Ryan has given his time up to answer questions that you may have. So far, we've talked about non-compete. We've talked about overtime. And we talked about salaried and unsalaried, but I also want to talk about, the at will or right to work state. And we always hear, oh, it's the right to work state. And people throw that out and they just don't really know what that means. So if you can let our listeners know what that really means for the employee and the employer, quite honestly.
Sure. So it's funny that you mentioned that, because one of the things that happens so often is people will say, it's a right to work state, and they can do whatever they want because it's a right to work state, and that's not the right concept.
Right.
Right to work is an idea that it comes out of the union setting, and whether or not that employees are required to be members of a union to work in a specific location. Well, there are no businesses in Florida, of course, there's always a few exceptions, but generally in Florida, you can't be required to be a member of a union to work for a business. And so the idea behind a right to work is not something that comes up in Florida at all. Right to work deals with open shops and closed shops. A closed shop means you have to be a member of the union to work there. An open shop means anybody can work there. But those really don't come up in Florida. What we do have in Florida is this concept of employment at will. And employment at will is a judicially created concept that says that you can be fired at any time for any reason unless it's an illegal reason, and you can quit your job at any time for any reason. And that's the idea is there's not slavery, there's not indentured servitude. You can quit at any time unless there's a contract or something, and you can be fired at any time for any reason at all except an illegal reason.
And that's why I always say it's not a right to work state, it's a right to fire state.
That's
and
right.
If there's an issue, call Ryan.
I appreciate that. Yeah.
But there are some things that they can't fire you for. Is that right?
That's right. And really the focus, and one of the things, the first things that I talk with people about when they come to see me is, well, do you have any reason to believe that your firing was because of your age, your race, your religion, your gender, your national origin, your disability, or because of some whistleblowing? And those are the areas where if you believe that you were fired because of those reasons, maybe we can help you. So, right, like, they said to you during the couple of months leading up to your termination, we need to get some young blood in here. Boy, we got a lot of gray hairs in the office. The staff is looking a little long in the tooth. Comments like that suggest, hey, they're going to, and then, they let you go. Well, maybe that was because of your age and they were trying to fire people who were older workers. Or, God forbid, somebody is confronted with some racial slurs or something like that. That certainly suggests that there's a racial element to the termination. Or somebody is subjected to sexual harassment or an unwanted touching or unwanted comments, those kinds of things. Those are bases that would be unlawful, and it's illegal to fire somebody. It's illegal to fire somebody if they complain about those things, right? So if somebody goes to the employer and says, "Hey, I'm being sexually harassed by my coworker, or I'm being sexually harassed by my boss," and instead of actually investigating that, they fire the employee who's brought forward the concern, that's unlawful as well. And unfortunately, that happens. It's difficult. It takes a lot of guts for people to stand up and say, what is happening to me is wrong. And it's really unfortunate when the employer's response is, we're going to fire the employee, rather than addressing the real problem.
That is a problem, and I think you probably see it.
It's a lot of what we do. Yeah.
Yeah. We, in our workers' comp cases, we often have clients who, are get injured on the job. And it's a compensable, legitimate injuries, no dispute about that. They're off of work. They're getting their temporary total or temporary partial disability benefits. And then they reach maximum medical improvement, or MMI. And they say, okay, I'm ready to go back to work. And the employer says, I don't have a job available for you. Sorry, so sad. And many times the employee is like, Matt, do something about that. And I think I'm correct. They don't have to hold your job open for you if it's because of a workers' comp injury.
Now, it's funny, but workers' comp, we used to call it the Bermuda Triangle. There's workers' comp and the Americans with Disabilities Act and the FMLA. And the way those three laws interact can be very confusing and very complex. And so, they may not have to hold your job under the workers' comp law. Depending on the size of the employer and the nature of what's going on, maybe you're entitled to leave under the FMLA, which would be 12 weeks of unpaid leave. Or maybe as under the Americans with Disabilities Act, you might be entitled to leave as a reasonable accommodation, a leave for a defined period of time. And it's again one of those areas of the law where we see the workers' comp, and we chat with our colleagues who do workers' comp about how it is we might be able to find a claim for that person who wasn't brought back to work. But unfortunately, often the treatment periods for workers' comp injuries can be so long, and they're going to the comp doctor and they're dealing with that whole process, that they would exhaust whatever leave they're legally entitled to, and they're beyond that period of time.
That's what I was going to ask you. It's the 12 weeks for FMLA of not getting a check.
Right.
The argument that I sometimes hear, which I think I asked you a while ago, and you educated me, it's not 12 weeks from the last workers' comp check you got, but rather it's the last 12 weeks from the last employment check you received.
Well, the last day you worked.
Right.
Okay. And so what happens is, and employees sometimes think, oh, well, I can stack my vacation and my sick leave and all of those things. And unfortunately, the law doesn't require the employer to do that. The law doesn't require the employer to allow you to stack your leave. And so it's really 12 weeks of leave is what you're entitled to under the FMLA. And so, and it's not paid leave that you're entitled to, but the paid leave counts against your 12-week entitlement. So imagine for a moment that you have 3 weeks of vacation that you get to use, and the employer says, okay, well, we're going to give you the 3 weeks vacation paid, and now you've got 9 weeks of unpaid leave. You don't get the 12 weeks on top of the 3 weeks. You only get a total of 12 weeks. So it's 3 weeks of paid and 9 weeks of unpaid, and that's it. And that can be a hard thing for an employee to sort of confront, that they're not going to be able to go back to that job. The employer's not required to hold that job for them beyond that period.
I have a case. I won't say the name of the big furniture company, but my guy is 70 years old, maybe 65, but he delivered furniture for this big company for 30 years. 30 years he was delivering, and he lifting up a big piece of furniture. I think it was a dresser, walking upstairs, and he had a twinge in his knee and he needed to have knee surgery. Well, all he's done for all his life is work for this big company for 30, I think it was 36 years. And they gave him the 12 weeks and then said, see you later. We don't need you anymore.
Yeah.
And I wish he had a claim.
Yeah.
But
it is and it's unfortunate. And that is what we see so often is, again, people and he felt devoted to that company.
Sure.
And he felt that there was something that there was a reciprocal relationship. And unfortunately, that's not the case anymore. Employers don't feel that loyalty back to the employees. And, if they can do it less expensive by outsourcing or sending your job offshore, that happens right now with a frequency that is very concerning. And, with the use of AI and everything else, you're seeing employers doing everything they can to really push people to do more for less at lower cost. And there's a societal impact from that.
Sure. Have you seen an impact with AI in employment law?
Absolutely. Virtually every person who comes to see me has written up not in their own mind, but with AI, a list of questions they want to ask me. And often people who are contacting me are sending me a list, a description of what happened at their job that was written by AI.
Okay.
The list of questions that they want to ask me, I'm happy to talk with people about questions that they have. Sometimes those questions aren't that helpful because the computer doesn't really know what happened at the person's job.
It's facts. You need to know facts.
Facts. Yeah. And the AI summaries that people prepare are really not very helpful at all because they tend to use grand terms and they look pretty, but at the end of the day, I just want to know what happened at work. I want you to tell me what happened at your job, what happened at work today, what happened. And it's much more like the conversation that you're going to have with your spouse rather than a conversation you want to have with a computer. Tell me what happened at work. Tell me what's going on at your job. That's the conversation I need. And the conversation about egregious circumstances, that doesn't tell me anything. Somebody said this mean thing to me, or they did this bad thing. That's what I want to know. I don't need the egregious circumstances described as egregious.
And you probably need to know what the sayings are. Just, hey, they said comments that made it sound like they were age discrimination. What were those comments?
That's right. Right.
And AI can't do that.
No, AI doesn't do that. Yeah. It describes it, but it doesn't really tell me what it is going on at your job. And that's what we really want to know.
How hard is it to prove a case of let's say age or sex discrimination?
Unfortunately, the numbers for plaintiffs being successful are really bad. The courts are hostile to these types of cases. There's no way around that. Statistically, plaintiffs have a very hard time with their claims. The courts use a number of different tools to sort of weed these cases out and make them hard for employees to win. With that said, I'm able to feed my family doing these cases, and in part, it's because we fight hard for people. We do what we can. If we can get a settlement for somebody that makes sense, we help them negotiate that settlement. If it's a case that needs to be litigated, we litigate those cases. But these are very difficult cases, and there are a lot of sort of procedural roadblocks that have been thrown up to keep people from bringing claims, and a lot of ways that the court has put roadblocks in to make it more difficult. And one of the examples that I always use is what human beings and Americans think would qualify as sexual harassment that you can sue for, and what the courts recognize as being actionable sexual harassment are very different things. Oh. Conduct that I find outrageous and that I find amazingly inappropriate, there are lots of court decisions that the court say, oh, well, that's not really that bad. Or the employee didn't suffer that many instances of sexual harassment, and so the employer doesn't have to defend that case. It's really stunning.
Well, and although our areas of law are different, I think our philosophy of how we handle them are very similar. If you have to take it all the way to a trial, you will take it all the way to a trial. I've heard and I've seen you do it. So, but sometimes it's better for the client to reach a compromise agreement.
Yeah, I think it's ultimately the client's decision, and we try and give people guidance and advice, and help them and support them as they make that decision. And I say a lot of times to my clients, tomorrow I'm going to do this again. I'm going to have another client and I'm going to do this again. You're only hopefully going to go through this the one time.
Right.
So you need to have agency. You need to be comfortable with the decisions we're making. You need to be involved and thoughtful, and I'll talk with you and I'll help you, but you need to be comfortable with the decisions that you're making. And sometimes the decision that's made is this settlement is a good outcome, right? It's a certainty. I get things done. I get moved on. And sometimes there's the decision is made is, no, we really need to try this case. And that's what we do. I'm happy to try a case. I joke that nobody becomes a lawyer to get to just take depositions. When you're thinking about becoming a lawyer, you're like, I want to be in the courtroom. I want to be arguing. I want to be doing the Perry Mason moments. Right. And so to the degree we can have those Perry Mason moments, that's a lot of fun. And that's what we all want to do.
Right.
But you're also mindful of what's in the client's best interest at any given time.
Right. No, I agree 100%. That's why I like you, because it's the same type of philosophy that we've had and we've always had. Fight when you need to fight, but resolve when you can. And I think that builds respect on the other side as well, they know you're going to fight if you need to fight it.
Yeah.
You know,
I think there's a value to lawyers knowing that the lawyer on the other side of the table is willing to try a case and in the right instance is going to take the case to trial, because at the end of the day, if you're not willing to do that, you're not going to get as good outcomes for your clients.
Sure. So if someone feels that they were fired unfairly, what would you recommend the first thing they do?
So, I think the first thing really is, the employee should think about, okay, what do I think was unfair about this? Do I think it was because of some illegal reason? Do I think it was because of my age or my race or my gender or my national origin or my disability or whistleblowing? Or do I think it was just mean and stupid? Because if it's just mean and stupid, I can't necessarily help you with that. It's got to be this illegal element to it. And they don't have to be, they don't have to worry about using big words to describe that or sort of complex concepts. But I think they did this to me and I think it was wrong or illegal for this reason.
Right.
And then at that point in time, they can come and see a lawyer like myself. We were talking about the pandemic earlier. One of the things that's happened in my practice is it used to be everybody came into the office and we had all in-person consultations. Now probably 90% of my consultations are over Zoom, maybe more. Most people don't want to come into the office anymore. They want to talk to me over Zoom, which is fine. They get to do it from the comfort of their house. I do it from the office and we work through those issues. They send me the documents beforehand. We look over them and we do it. But it's another one of the changes that's happened in terms of the nature of the practice.
I'm old school. And so I do always say, I want them to come in. I want them to come in. And my staff will say, they don't want to come in. I said, okay, that's fine.
Yeah.
Because it is up to them. But you feel like you want to be there and be, but
it's funny. I mean, for years, I wouldn't do it. I wouldn't do depositions over Zoom, and I wouldn't do client intakes over Zoom. I really, or the predecessors to Zoom. I really needed people to be in the office. Now we've just gotten so used to doing them over Zoom.
Yeah.
It's funny because in some ways, if we're looking at a contract or if we're looking at a severance agreement, the ability to have the person look at it on their screen and me highlight the provisions and then go back and show them the law and how the law interacts with that contract provision, those are things that would be to some degree more difficult to do in the office.
That's true.
I find that when I'm doing if somebody has a severance agreement, for example, they've been fired from their job and their employer's offering them a severance package to agree not to sue them. We'll talk with them and walk through the agreement and explain what those provisions mean and talk with them about if they want to try and get more and negotiate or possibly litigate to get more. And the ability to put that agreement up on the screen and highlight the provisions and walk through what the various sections mean, the computer is very good for that. And that's a very useful interaction to have over Zoom.
And how can they get in touch with you? Sure. I know we're about to wrap up, so I want to make sure that they know how they can get in touch with you if they have questions after tonight's show.
Sure. So we have a website. It's employeerights.com. And so that's the best place to get in touch with me, employeerights.com.
And what's the telephone number for your office?
727-441-4947.
And if you didn't get that information, you can always call our office at Paranet Caulfield, Averill, and Noyes at 727-796-8282. Or just keep listening to FLA Law on the radio and call us, and we'll be happy to give you the question. Brian, thank you very much. I've seen you on our TV show, but now I'm very glad that you've been a guest on our radio show.
Happy to do it. Thank you so much.
Thank you very much. And thank you, listeners, for listening. We'll be back next week as well at 5 o'clock on Tuesday. But in the meantime, as I always say, drive carefully and watch out for those who don't. Take care.